Greetings, my fellow freedom lovers and sovereign thinkers. This is LL3's News Podcast. My name is Craig, transmitting from the beautiful swampy mangoes of South Florida, and today's date is Tuesday, February 12th, 2019. So let us begin. Thanks for tuning in, my friends. Just chilling right now in my camper. A little quiet, a little windy out there today, so I have to do this more outdoors. So once in a while, I do it inside. Yeah, on this day in history, Abraham Lincoln was born. People say he was a great man, but I'll say one thing for sure: he wasn't really freedom friendly. With all due respect, I like to do a shout out to VSSA Daily, which is anchoring for Virginia Shooting Sports Association, which their official National Rifle Association affiliate association. And for sharing my podcast on their latest paper on site, to be exact. They thanked me, so I thank them for sharing. It's very important. It's the episode I did last. H.R. 8 contradicts Roe versus Wade and beyond. So, like I tell everyone before, for all you folks out there that examines H.R. 8, which it means Bipartisan Background Checks Act of 2019, is anti-Roe versus Wade. Just hear that last episode, got all the footnotes, and you could hear my voice and read for yourselves. Alright, without further ado, I'm going to start off everything here pertaining to nullification. But before that, sorry about that, my mistake. Always got to look at what's around us. Of course, Venezuela, Congo, a lot of stuff is happening around the world, conflicts, and stuff you don't hear on the garbage media. So, always observe responsibly. Alright, so mainly I'm going to be talking nullification stories, which I thank the 10th Amendment Center for putting this out. And the first thing we'll start off by Mike Meharry. Says here, Missouri bill take on federal gun control, past, present, and future. And as it reads here, came out February 11th, bill introduced in Missouri legislature who set the foundation to create gun rights sanctuary state by banning state and local enforcement of the most federal gun control. Passage into law would represent a major step toward ending federal acts that infringe on the right to keep and bear arms within the state in practice and effect. Senator Eric Burleson, a Republican from Battlefield, introduced Senate Bill 367, and Jeff Paug, Republican from Salem, introduced House Bill 785. This is 76 as well. Interesting here. Titled Second Amendment Preservation Act, the legislation would ban any person, including any public officer or employee of the state in its public political subdivisions, from enforcing any past, present, or future federal acts, laws, executive orders, administrative orders, court orders, regulations that infringe on the right to keep and bear arms. The bill includes a detailed definition of actions that qualify as infringement, including taxes and fees on firearms, firearm accessories or ammunition that would have a chilling effect on firearm ownership, registration and tracking schemes apply to firearms, firearm accessories or ammunition that would have a chilling effect. Any act forbidding the possession, ownership, or use or transfer of a firearm, accessory, or ammunition by law-abiding citizens. Any act ordering the confiscation of firearms, firearm accessories, or ammunition from law-abiding citizens. Interesting. A lot of pro-Bill of Rights. They have their own state constitution as well. Maybe it's Declaration of Rights. I'm not so sure, but you can look it up. Just type it in, Missouri Constitution, and you can take it from there. This would include the National Firearms Act of 1934, the Gun Control Act of 1968, and more, such as President Trump's new bump stock ban. I want to take a moment here to thank Senator Rand Paul, Republican from Kentucky, for saying he will vote no on the candidate for Attorney General, William Barr, because he is not freedom friendly. He hates the Bill of Rights, period. And I'm not the only one that says that. This legislation includes a provision that would allow anybody who violates the law and knowingly deprives somebody of their right to keep and bear arms as defined by the law to be sued for damages in civil court. They should get them for jail time as well. Sovereign, official, or qualified immunity should not be an affirmative defense in such actions. The bill includes provisions that would apply to federal agents who knowingly enforce or attempt to enforce any of the infringing acts identified in the law, or who gives material aid and support to such enforcement efforts. Under the proposed law, they would be permanently ineligible to serve as a law enforcement officer or to supervise law enforcement officers for the state of any political subdivision of the state. This would also apply to state or local enforcement agents working with federal task force or deputized by federal agencies. In other words, Missouri law enforcement officers who cooperate with the feds in a violation of a person's right to keep and bear arms would lose their jobs and never be able to work in Missouri law enforcement again. Woo! I'm going to expect that to be a union dispute. That's going to be a big question in the PBA and FOPs within the Show Me state. Effective. The federal government relies heavily on state cooperation to implement and enforce almost all of its laws, regulations, and acts, including gun control. By simply withdrawing the necessary cooperation, states and localities can nullify in effect many federal actions, as noted by the National Government Association during the partial government shutdown of 2013. States are partners with federal government on most of federal programs. Based on James Madison's advice for states and individuals in Federalist Papers 46, a refusal to cooperate with officers of the Union represents an extremely effective method to bring down federal gun control because most enforcement actions rely on help, support, and leadership from states and local governments. Fox News senior judicial analyst Judge Andrew Napolitano agreed. In a televised discussion on the issue, he noted that a single state taking this step would make federal gun laws nearly impossible to enforce. Partnerships don't work too well when half the team quits, said Michael Bowden of the 10th Amendment Center. By withdrawing all resources and participation in federal gun control, states and even local governments can help bring these unconstitutional acts to their much-needed end. Some gun rights supporters have argued that such a measure is unnecessary because it addresses a non-existent problem with a Republican Congress and an NRA-backed president. Trump's bump stock ban obliterates this fallacy. Furthermore, the Trump administration actually ramped up enforcement of federal gun laws in 2017. So they need to shut their lid. It's called an insurance policy. Legal basis. The state of Missouri can legally bar state agents from enforcing federal gun control. Refusal to cooperate with federal enforcement rests on a well-established legal principle known as the anti-commandeering doctrine. Simply put, the federal government cannot force states to help implement or enforce any federal act or program. The anti-commandeering doctrine is based on primarily of 5 Supreme Court cases dating back to 1842. Prince versus the United States serves as a cornerstone. You may hear a train going by. That's okay. We held in New York that Congress cannot compel the states to enact or enforce a federal regulatory program. Today, we would hold that Congress cannot circumvent that prohibition by conscripting the states' officers directly. The federal government may neither issue directives requiring the states to address particular problems, nor command the states' officers of their political subdivisions to administer or enforce a federal regulatory program. It matters not whether policy making is involved, and no case-by-case weighing of the burdens or benefits is necessary. Such commands are fundamentally incompatible with our constitutional system of dual sovereignty. What's next? At the time of this report, neither SB 367 nor HB 786 has been referred to a committee. Once the bill receives assignments, they will have to pass their respective committees by a majority vote before moving forward in the legislative process. To everyone else in the Show Me state, call them out. Don't be shy. Put out the truth. I think this is fantastic. Nullification works. Just look at the 18th Amendment. Very good example. And the Fugitive Slave Act as well. So, I am very pleased about this. I support it 100%. I think my state of Florida needs to get on the program as well. When states nullify, federal laws, federal programs, all that are done. So, I think it's really, I'm very happy about this. And it's pro Roe versus Wade as well. All right. Well, next one here, my friends. The kid came from same thing, 10th Amendment Center, and this is by Mike Meharry again. It says here, Tennessee legal tender law would treat gold and silver as money. Foundation to undermine the Federal Reserve. This is in Tennessee. Fantastic. What it reads here. Bills introduced in the Tennessee legislature would define gold and silver specie as legal tender and eliminate sales taxes levied on it. Passage of these bills will pave the way for Tennessee residents to use gold and silver in everyday transactions, a foundational step for the people to undermine the Federal Reserve's monopoly on money. Senator Steve Sutherland, Republican from Morristown, introduced Senate Bill 978 on February 6th, and Representative Wick Elridge, Republican from Morristown, introduced the House Companion Bill, HB 1323, the same day. The title, the Tennessee Legal Tender Act. The legislation would make gold and silver legal tender in the state, meaning it would be recognized as a medium of exchange for the payment of debts and taxes. Practically speaking, gold and silver specie would be treated as money, putting it on par with the Federal Reserve notes in Tennessee. Well, we can say this. Article 1, Section 10 of the U.S. Constitution says it can be done. All right, it says right here, specie legal tender would be defined as 1, specie coin issued by the United States government at any time, and 2, any other specie that a court of competent jurisdiction by final and unappealable order rules to be within state authority to make or designate as legal tender. By allowing the court to designate additional specie to be used as legal tender, Tennessee could free its citizens from potential supply constraints imposed by the use of the United States minute gold and silver coin. More importantly, the people of the state of Tennessee would be able to define what specie is considered constitutional tender, further distancing themselves from potential control over their competing currency by Washington, D.C. That would really offend the World Bank and the International Monetary Fund, right? Absolutely. SB 978 HB 1323 would also repeal the state sales tax on gold or silver specie. In practice, with the passage of SB 978 and HB 1323, Tennessee would take a step forward, treating gold and silver specie as money instead of a commodity. As Sound Money Defense League Policy Director J.P. Cortez testified during a committee hearing on a similar bill in Wyoming last year, changing taxes on money itself is beyond the pale. And effects that collects on purchases of precious metals are inherently saying gold and silver are not money at all. Imagine if you ask a grocery clerk to break a $5 bill and he charged you a 35-cent tax. Silly, right? After all, you are only exchanging one form of money for another. But that's essentially what Tennessee's sales tax of gold and silver bullion does. By removing the sales tax on exchange of gold and silver, Tennessee would treat specie as money instead of commodity. This represents a small step toward a reestablishing gold and silver as legal tender and breaking down the Fed's monopoly on money. We ought not to tax money, and that's a good idea. It makes no sense to tax money. Former U.S. Representative Ron Paul said during a testimony in support an Arizona bill that repealed capital gains tax on gold and silver in that state. Paper is not money, it's fraud, he continued. The proposed law's impact would go beyond mere tax policy. During an event after the Senate committee testimony, Paul pointed out that it's really about the size and scope of government. Here's what he says here. If you're for less government, you want sound money. The people who want big government, they don't want sound money. They want to deceive you and commit fraud. They want to print money. They want a monopoly. They want you to get conditioned, as our schools have conditioned us, to the point where deficits don't matter. Practically speaking, officially making gold and silver especially legal tender and eliminating taxes on the sale of gold and silver would crack open the door for people to begin using specie on regular business transactions. This would mark an important small step during currency competition. If sound money gains a foothold in the marketplace against Federal Reserve notes, that people will be able to choose the time-tested stability of gold and silver over the central bank's rapidly depreciating paper currency. In 2011, Utah became the first state in over 80 years to pass a law making gold and silver coin legal tender. The following year, the legislature followed up, approving a bill clarifying several tax measures and, more importantly, expanding the definition of specie to include gold and silver coin. Approved by the state. With the law in place, United Precious Metals Association opened a gold bank that offers publicly available accounts denominated in gold and silver dollars in Utah. According to the UPMA, in the past year, it has grown 700% in assets under management, made up 2% of the market for U.S. gold and silver coins. Account holders can make everyday transactions using their accounts through a debit card system. Background information: the United States Constitution in Article 1, Section 10, no state shall make anything but gold and silver coin in a tender and physical and payments of debts. States have simply ignored this constitutional provision for years. It's impossible for a state to return to a constitutional sound money system when it taxes gold and silver as commodity. SB 978 and HB 1323 would take a step toward establishing gold and silver as a legal tender in the state, and that constitutional requirement ignored for decades in every state. This sets the stage to undermine the monopoly of the Federal Reserve by introducing competition into the monetary system. Constitutional tender expert Professor William Green said when people in multiple states actually start using gold and silver instead of Federal Reserve notes, it could create a reserve Grinjams effect. Drive out bad money, effectively nullify the Federal Reserve and the federal government's monopoly on money. Over time, it says here, over time as residents to the state use both Federal Reserve notes and gold and silver coins, the fact that the coins hold their value more than Federal Reserve notes will lead to a reverse Grinjams law effect, where good money, gold and silver coins, will drive out bad money, Federal Reserve notes. As this happens, a cascade of events can begin to occur, including the flow of real wealth toward the state's treasury and an influx of banking business from outside of the state as people in other states carry out their desire to bank with sound money, and eventual outcry against the Federal Reserve notes for any transactions. One things get to that point, Federal Reserve notes would become largely unwanted and irrelevant for ordinary people. Nullifying the Fed on a state-by-state level is what will get us there. What's next? At the time of this report, neither bill has been referred to a committee. Once they receive committee assignments, they will have to pass by a majority vote before moving forward in the legislative process. So, the truth of the matter is, my friends, they got to make this a reality. Okay? People in that state, make it happen, my friends. Volunteer your time and saying, I want sound money. I'm tired of monopoly money. That is from the Federal Reserve. And you know what? Keep it up. Things are happening, my friends. And the one thing I like about this so far, yeah, a lot of crazy things are going on. They all want to go hate Trump this, Trump that, but all hot air. And you know me for sure. I'm critical towards anybody. I'm going to back it up with Barrett. So I encourage everyone out there in the volunteer state to say, yes, nullify the Federal Reserve by supporting this Tennessee Legal Tender Act. Okay, next one here. Same thing. 10th Amendment Center once again came out on this February 7th, so 5 days ago. No trains coming by. It says here, Wyoming Senate passes bill to take over operation of federal facilities during the shutdown. Ooh. It says here, yesterday, the Wyoming state passed a bill which will allow for the state to temporarily take over operation of federal lands in Wyoming in the case of another shutdown. Introduced by Senator Charlie Scott, Republican from Casper, Senate File 148. Create a process by which state would take over operation of federal facilities such as national parks. If the federal government of the United States is unable for any reason to successfully operate any national park or other federal facility located within Wyoming, the bill calls for process to return those lands to the federal government once the shutdown ends. The legislative empowers the governor to take any steps necessary to protect any natural wonder, wildlife, and plant life, cultural resource, and other natural feature contained in the federal facility. It also requires the governor to take actions that he judges appropriate to ensure that public access remains normal, and actions that he judges useful to facilitate the normal operation of concessionaires and lessees within the federal facility. In response to statements from a prominent Wyoming law professor calling measure unconstitutional, Scott said, "When a push comes to shove, we're not going to let the foolishness in Washington stand in the way of using common sense." That is cool. An amendment approved by the Senate this week removed the word "seize" in multiple areas of the bill elevate concerns of some opponents. On third reading, the Senate passed SF 148 by a vote of 17 to 12 yesterday. What's next? SF 48 will now move over to the House, where it will be first need to be assigned and to approved by the committee, so the full House has an opportunity to concur. Hey, I say, you know what? Make it work. 10th Amendment style once again. I like this so far, man. It's great. We got to be doing that everywhere you go, okay? And then you have the park rangers in there. If it doesn't work, give them a job, you know? See you can match up, do parity what they have now, etc., and just take it from there. But hey, I'm loving this every minute of it. And I do remember too, they had a sovereign state resolution as well. And the fact is, the governor who signed it into law was a Democrat. Yeah, see? I'm not saying all Democrats are bad or Republicans, but you got your pros and cons everywhere you go. So, always got to look at the fine print, my friends. Okay, one more here. Came from Maryland. Bill would end federal asset forfeiture program in the state. February 7th by Mike Meharry. And it reads here, a bill introduced in the Maryland Senate will close a loophole allowing state and local police to circumvent stringent state asset forfeiture laws by passing cases off to the feds. Senator William Smith, Democrat, introduced Senate Bill SB 764 on February 4th. The legislation would withdraw Maryland from a federal program that allows states and local police to get around more strict states' asset forfeiture laws. It is particularly important in the light of a policy directive issue in July 2017 by then Attorney General Jeff Sessions for the Department of Justice. In 2016, Governor Larry Hogan signed a significant reform to Maryland's asset forfeiture process into law that also included detailed reporting requirements, but the reforms left open a loophole that created an avenue for police to bypass the more stringent state requirements. I think I talked about that in my past episodes as well. A federal loophole, a federal program known as equitable sharing, allows prosecutors to bypass more stringent state asset forfeiture laws by passing cases off to the federal government through a process known as adoption. The DOJ directive reiterates full support for the equitable sharing program that directs law enforcement agencies to aggressively utilize it and sets the stage to expand it in the future. Law enforcement agencies can circumvent more strict state forfeiture laws by claiming cases are federal in nature. Under these arrangements, state officials simply hand cases over to a federal agency, participate in the case, then receives up to 80% of the proceeds. Can we say blackmail? Absolutely. However, when states merely withdraw from participation, the federal directive loses impact. Until recently, California faced this situation. The state has come the strongest state-level restrictions on civil asset forfeiture in the country, but state and local police were circumventing the state process by passing cases to the feds. According to a report by Institute for Justice, Policing for Profit, California ranked as the worst offender of all states in the country between 2000 and 2013. In other words, California law enforcement is passing off a lot of cases to the feds and collecting the loot. The state closed the loophole in 2016. Look at that. The Golden State was good on this one. Yes, the gun laws over there I'm very critical of that. When they do something right, I give them the thumbs up. I believe Jerry Brown signed it into law, so you can thank him for that, even though I'm not crazy about the guy. But I will proceed. The asset forfeiture reforms instituted in 2016 included detailed reporting on Maryland's law enforcement participation in the Equitable Sharing Program. SB 764 would close a loophole and end Maryland's participation in the program altogether. A forfeiting authority or seizing authority may not receive the proceeds of or enter an equitable sharing agreement with the federal agency to receive the proceeds of property subject to forfeiture under Statute 12-102 of this title that is forfeited under federal law. As the 10th Amendment Center previously reported, the federal government inserted itself into asset forfeiture debate in California. The feds clearly want the policy to continue. Why? We can only guess, but perhaps the feds recognize paying states and local police agencies directly in cash for handling their enforcement will reveal their weakness. After all, the federal government will find it nearly impossible to prosecute its unconstitutional war on drugs without state and local assistance. Asset forfeiture, equitable sharing provides a pipeline to the feds to use this incentivize state and local police to serve as a de facto arms of the federal government by funneling billions of dollars into their budgets. What's next? SB 764 referred to the Senate Judicial Proceedings Committee, where it will need to pass a majority vote before moving forward in the legislative process. It is scheduled for a public hearing on February 22nd at 12 p.m. So the folks in that area of the Commonwealth of Maryland, or Maryland, whatever you want to call it, make it happen. Keep these parasites on their toes. I think it's fantastic. This is why you can be critical, but they're doing something right. Back it up. Principle over party. And this here, civil asset forfeitures, is nothing more than extortion. And to be very frank, these individuals should be thrown in jail for extortion, robbery, grand larceny. So, I'm very thrilled about these areas. It's an exciting time to be alive, my friends. There's another thing, too. Maryland was the first state to nullify the 18th Amendment of the U.S. Constitution. Prohibition. All right? Look it up. You'll be amazed. All right, my friends, that is it. I'd like to thank everyone for listening. Plus, feel free to download and share us on social media networks. If you have any questions, comments, or if you send something that's interesting you want to check out, whatever you do, please send your correspondence with decorum. Plus, I will leave all my information, social media sites, and email addresses. And that's it. Once again, thank you for your time. Plus, always remember that demoniac resistance, healthy for the soul, and can liberate humanity. Until next time, take care of yourselves. Keep on spreading the love, and may your guardian spirits be with you.